Okay, so here's something that's interesting. NOAA, which stands for the National Oceanic and Atmospheric Association, recently released information that said as of 2017, there were 16 disasters on record with an average of 1 billion apiece. Now, frankly, I think that's a little conservative because information just came out here in California that the 2017 California wildfires have an estimated claims loss of $12 billion. So the point is right now we have a tremendous loss going on in the area of property damage and homeowners insurance. And that's the point of this talk. We're here today to deconstruct a homeowner's policy. What I'm going to walk everyone through is what's called the H0003 policy. That's a standard homeowner's policy. Okay, so that's going to be the focus of this information as it relates to property damage. Now, there's a couple of things I want to go over from the very beginning to let you know that we will not be discussing. All right, so there's no misunderstanding. We're not going to be discussing condo policies. We're not going to be discussing renters policies. Now, a lot of the information that I will discuss here is relevant and it's applicable to those policies, but that's not the focus today. Again, the focus is on the homeowners policy, the standard one, which is the H0003. Secondly, we will not be speaking about any commercial policies. Again, some of these principles may be applicable, probably less so. Some of them may be, but again, that's not going to be the focus of today's talk. Thirdly, we're not going to be speaking on the Section 2 liability portion of the H0003 policy. That policy itself is really broken down to two sections. You have Section 1, property damage, which will be the focus of this talk, and Section 2, liability, which will not be the focus of this part. Fourth and final, almost every general principle I lay down will be subject to some exceptions. I mean, us lawyers know that. And so I'm not going to be expounding upon these exceptions and the exceptions into the exceptions. I'm just going to be laying down general black letter law and leave the exceptions aside. So, leading off by saying what we are not discussing, let me discuss what we will be discussing. So we're going to take the H0003 policy, and there's some written materials provided you can follow along, and basically we're going to deconstruct it. Okay, so we're going to take a look first at the declarations page, then definitions, then coverages, then exclusions, and then endorsements. And then we're going to wrap it all up with a discussion on disputes, first party and third party disputes. Now, when I'm going through the policy, I'm going to point out areas that are common areas of first and third party disputes. So then once we get near the end of the discussion and we're talking about disputes, I'll be able to provide, you'll have a framework at least to understand what I'm getting at with these disputes. So, that's going to be the focus of our talk. So real briefly about myself, my name is Evan Walker. I'm a solo attorney here in San Diego. I started practicing, I graduated law school in New Orleans in 2008. So, fun fact, Katrina was a Friday. My first week of law school ended on a Friday. All right, Katrina was Monday. Okay, so, no one expected that, right? So I wound up doing the whole evacuation to Houston and living off a FEMA voucher, et cetera, et cetera, et cetera. Coming back to New Orleans, 3 months after Katrina, and there was nothing there, not even birds, but people's refrigerators out on the street, right? So I only bring that up to say that I personally lived through Katrina. But what's more interesting is by the time I graduated, so 2008, so you had about 2.5 years by that time, New Orleans had erupted with Hurricane Katrina litigation. Okay, and it was on a massive scale. Commercial, residential, renters, whatever. There were so many claims going on. And I wound up getting hired by an insurance defense firm in New Orleans, and I represented insurance companies defending Hurricane Katrina claims. So I did that for a number of years. And then my wife, who was a physician, wound up going to the East Coast for residency. So I followed her to the great state of Connecticut, took that bar. wound up working for a large insurance company defending personal injury claims. I did that for a number of years, and in 2014, my wife and I moved here to San Diego for her to continue. She had a job here as an attending. And so I wound up taking the California bar and then opened up my own firm a few years ago doing plaintiff work. So I switched the side, and now, in addition to personal injury, I represent clients with property damage claims. So I only bring that up not to carry on about myself, but simply to let y'all know that I come at this from a defense and plaintiff perspective, seeing both sides of the fence. Okay, so that's what I can bring to the table. Now, let's kick off and get right into it. So, the declarations page. So we're looking at the H003 policy. What is the declarations page? A couple of things you need to know. One, it's basically going to be the first page of the policy, okay? So like they say, you know it when you see it, right? You get this huge stack of papers, and you're going to kind of rifle through the first couple of pages because it's going to be information from the insurance company. Hey, John and Jane Smith, thanks for being a part of our great family, you know, et cetera, et cetera. Get all that stuff out of the way, and then you'll get to a page that says declarations page. And again, that's going to be basically the first part of the policy. Now, what's important about this page, and I would say it's the most important page in the entire policy, is for the information that it has on there. Now, when you look at the declarations page in the context of the rest of the policy, I would say the declarations page is the most important because this is the information that is tailored to the insured, right? Everything else about the policy, which we'll get into, the coverages, the exclusions, the endorsements, for the most part, it's all going to be standard language, right? My policy is going to have the same language that my neighbor's policy is going to have, basically. The difference is going to be the information that's contained in the declarations page, all right? So, what information is that? Well, first off, there are about 4 areas that you want to pay attention to when you pull up the declarations page. The first part is going to be the named insured. So who is that? Well, it's exactly what it sounds like. It's the insured under the policy. So you pull up my homeowner's policy, it's going to have my name, it's going to have my wife's name. Something to keep in mind, and we'll get to in a minute, when you go to the definitions page, the named insured definition may be larger, expanded upon than what's listed in the declarations page. That's something that's really important that we need to keep an eye out for. And we'll get to that in a minute when we talk about definitions. Getting back to the declarations page, you're going to have the named insured. Right below that, you're going to have the insured location. That's exactly what it sounds like, okay? Your home, 123 Beechwood Lane, all right? That's going to be listed there. Now, the same kind of tangent I gave about the named insured is applicable to the insured location, which is to say you can go to the definitions page and that insured location may be defined broader than you realize it. So the takeaway from that is at the beginning of any analysis, you want to go to the declarations page. You want to see, number 1, who is the named insured? Number 2, what is the insured location? That is the very genesis of any type of analysis when you're handling these types of claims. All right, it doesn't stop there, but that's the beginning. So, what else is on there? Well, after the named insured and the insured location, you're going to have coverages. And we will go over this, trust me, in depth when we go over the coverages. But suffice it to say, it's going to be coverage A, B, C, and D in most policies. Now, coverage A is going to cover your dwelling, all right? So that's 123 Beechwood Lane. It's your home, all right? It's also going to cover attached structures to your home. Let's say your garage, all right? Now, coverage B, on the other hand, is going to cover unattached structures to your home. Let's say a pool or a fence or a granny flat or even an unattached garage, all right? Now, coverage C is going to cover your personal property, all right? So that's all your stuff. That's your books, that's your suits, that's your dishes, your furniture, the pictures of your dog, your wedding album, whatever. All right, that's all of the personal property that is insured under coverage C. Coverage D is a mouthful. That's ALE, stands for additional living expense, also known colloquially as loss of use. Now, we will get into this in depth, but suffice it to say now that basically what coverage D covers is additional living expenses incurred by an insured due to a peril to the property. And again, I understand that's a mouthful, and we will deconstruct it in a minute, bit by bit, but that's what coverage C is. Now, real briefly, when you're looking at the coverages, something else you want to pay attention to is right across from each coverage is going to be a monetary limit, right? So for example, you look at coverage A and you run your eye across the page and it's going to say $200,000, all right? You go to B, $20,000. You go to C, $50,000. Now, what you need to keep in mind is if there's no monetary amount across from the coverage, arguably there's no coverage, right? So you have to have both, meaning you have to have the coverage listed and then a monetary amount, which is the policy limits, the coverage limits applicable to that type of coverage listed on the declarations page. Absent that, there's no coverage, all right? So, lastly, there's just a few kind of pieces of information about the declarations page you need to be aware of. One is a policy number that usually listed at the top. So obviously when you're making a claim and you want to refer to the policy, you want to refer to the policy number. Okay, anytime you're dealing with the insurance company. You also want to look at the policy period, and I've always seen them 1 year. So it'll say, May 1st, 2018 to May 1st, 2019 at 2:01 a.m. I don't know why they do the 2:01 a.m., but it's always been 1 year. Now that can be important because if a loss didn't occur within the policy period, well, there's no coverage, right? Regardless of whether you have, the coverage limit and the policy, et cetera, et cetera. If it did not occur during the period that the policy is in effect, there's no coverage for that loss. So that could be important. It's definitely something to be aware of. And then lastly, the declarations page is going to list your deductible and your premium, okay? So that's really, what you need to pay attention to when you look at the declarations page. Now, followed after the declarations page should be the definitions, all right? And you think about this like any other type of contract, right? Because essentially this is what the policy is. It's a contract. So when you look at a contract, you're going to have the preambles, right? And then usually after that, it's going to go into the definitions. Well, policy of insurance is no different, right? You're going to have the declarations page setting out the essentials, and then you're going to jump into the definitions. And frankly, for the most part, the definitions page is not that important. Now, that comes with a caveat. It can be, but for the most part, you want to skim through it. But there are two areas you want to take a look at, which we touched on briefly, which is what is the definition of an insured and what is the definition of the insured property. Now, you may remember when we spoke on the declarations page piece about the named insured. Okay, well, you switch over to the definitions page, you look up insured, and in most cases it'll say insured means the named insured. Okay, we know that. And it means A, B, C, and D, right? A common example would be what's called the resident relative exception, right? So this is important, right? Because like I said, you start your analysis with the named insured to see who is insured under the policy, but don't stop there, right? You want to bring that analysis over to the declarations page to see if there is someone else besides the named insured who may be entitled to coverage under the policy. That's important. For the same reason, it's important to look at the insured location. Again, that definition may be broader, right? It may provide broader coverage than you think of if you just would have went by what is stated in the declarations page, for example, 123 Beechwood Lane, all right? So that's something you want to pay attention to when you're looking at the definitions page, but frankly, that's really it. There's not much more, there's not much more to it than that. So, stepping over the declarations page, stepping through the definitions page, now we're going to get to the coverages. So this is the insuring agreement, all right? This is what a lot of people think of as the actual policy, right? No, it's not. The policy is the entirety of the documents, but basically, this is the crux of the matter, right? You take a look at it, it'll say page 1 of 15 and page 1 of 30, 1 of 20, right? So that is all of, the insuring agreement. That's really the agreement between the insured and the insurance company. Okay, so it's important to know what's in there. And basically what you're dealing with here is the insuring agreement is going to break into the coverages in detail and then the exclusions, which we will get to in a minute. Now, endorsements are usually found at the end of the insuring agreement, but really the insuring agreement goes after the coverages. Now, again, like I said, we're not going to get into Section 2 liability. There's a lot of that in the insuring agreement, but we're going to focus on Section 1 property damage, right? And so what that comes down to is the coverages, A, B, C, and D. So let's talk about each kind of in part, and I'll tell you what it is, give you an example, and tell you, basically 3 things you need to know about it. So let's start with A. So coverage A, like I said, that covers your dwelling, right? So when most people think of insurance and they say, okay, well, it's my home, you're right, okay? That's going to be coverage A. And again, it's also going to include attached structures to your home. So if you have a garage attached to your home, that's going to be covered under A. All right, so what's an example? Okay, well, a fire rages through the hills and it burns down your home. Okay, well, you're going to make a claim under coverage A. All right, that's it. Now, what are a few things you need to know about coverage A? Well, first and foremost, it's a common area of first-party and third-party claims. And if you think about it, that makes sense, right? Because if there's a loss to your property, whether it's a natural loss, and so you may be dealing with a first-party claim, or it's caused by the negligence of a third party, so you're dealing with a third party claim, the fact remains that in most cases the damage is going to be to the insured dwelling, right, to your home, okay? So you're really going to see most, if not all, disputes focused on coverage A, the damage done to the dwelling. Now, this is something that I want everybody to pay attention to because this is important. Now, coverage A, I don't know the exact numbers. I know you can Google it. I do know that it's over 50%. So over 50% of all homes in the United States are underinsured. Now, what does that mean? Okay, that means that there's not enough insurance to cover an insured in case of an entire loss, right? So here's an example. So let's take this example of a fire, raging down and burning up the property. Let's say your coverage A limits are $200,000, right? The fire comes, it destroys your home, complete loss. So you turn around and you want to get the policy limits at $200K, but you realize that the actual loss is $300,000, right? Because your home was uninsured or underinsured. So what do you do in that instance? Well, you hope, that you get the best case scenario, which is to say you get the policy limits of $200,000. But that's not even a given, right? Because you're going to have to eat the $1,000 deductible, and there may be some other reasons why the insurance company doesn't just come out and cut you a check for $200,000. But even if they did, you're still underinsured by $100,000, right? So that's a huge loss. And so it's so important to make sure your home has adequate insurance. I'm not going to go, there's a whole mathematical formula about the square footage. I'm not going to go into that. I will say that myself, I recently looked at our homeowners policy and realized that we were underinsured. So I went and I made the appropriate changes, which is to say, I called the insurance company and said, okay, I want higher limits under my coverage A, right? And that should take care of the situation.
The first code is 688. The first code is 688.
The other thing I want to mention about coverage A is that you want to avoid what's called market cost, and you want to get replacement cost coverage. All right, so what do I mean? So normally with coverage A, you're going to have market cost, right? So in the event of a total loss, that means what does a market say, the value is, right? But you may not want that. I recommend you get replacement costs, which happens to mean that what will it cost to replace the home in the event of a loss, right? So that can, not always, but that can help offset any issues you may have with underinsurance dealing with coverage A. So that's really all there is to say about coverage A. So let's switch gears and talk about coverage B. So like I mentioned when we had the discussion about the declarations page, coverage B covers other structures, right? But remember, it's other structures unattached to your home. And structures has a broad definition, all right? So it means a fence, okay? It means a pool. It means an unattached garage, right? It could mean a shed, okay? It could mean, a granny flat, all right? So that's what coverage B is going to cover. Now, let me back up. Let me give you an example of that. So let's just say that wind comes down and it picks up your fence and throws it in your neighbor's yard. All right. If that happens, so what you have then is a claim under coverage B, right? Not anything else. If all the wind did was picked up your fence and threw it out, you don't make a claim under A or anything else. You make a claim under B, subject to the coverage B limits. All right. Now, few things to keep in mind with coverage B. One is that usually coverage B limit should be 10% of the coverage A limit. So for example, you have coverage A limits of $200,000, your coverage B limits are going to be $20,000. All right? Now, why is that important? Well, it's important because of this. It's a common area of first party and third party disputes, right? For the same reason that, coverage A is, right? If you have damage to your dwelling, chances are you're probably going to have damage to the other structures, right? That, if a fire comes down and burns up your home under A, chances are it's going to burn up the granny flat, right, covered under B. So they usually kind of go hand in hand. There's only been a few times where I haven't seen them go hand in hand, so that's something to be mindful of. Now, let's talk again about underinsurance, because the status quo basically, again, is like I said, is to have coverage B limits to be tied to coverage A, and they should be 10% of coverage A. In most cases, that's accurate, right? I think that's what we have in the case of our home. So not really much thought there. But here's what could be a problem. Let's say you have a granny flat, right? And you spruce it up, you make it really nice, right? You've done some work, you've added some plumbing, et cetera, et cetera, et cetera. You have your in-laws come and stay, your college friends come and stay. It's a house unto itself, right? So you did a really nice job. Well, if you would have left the policy as it is, that would have meant that that the coverage B limits would be 10% of your coverage A limits. Maybe your coverage A limits are fine, but let's say that fire comes down and it burns up the home, $200,000 loss, so you get your $200,000, and it burns up the granny flat, right, which is insured for 10%, which is $20,000, but it's going to cost you $60,000 to rebuild it back in the condition what it was, right? So in that instance, again, you're dealing with underinsurance. And again, I keep bringing this up because it's so important, right? And so many people are simply unaware that their home is uninsured. And we're going to be seeing a ton of that in the California wildfires, and frankly after Houston and a hurricane and everything else. So it really is time, personally and professionally, to do the due diligence and make sure that your home has adequate insurance, right? So you got to look at coverage A, you got to look at coverage B. Now, C, sometimes it matters, not so much. D, not really going to be an issue. Definitely for A, definitely for B. So, I'm done. So now let's switch over to coverage C. All right, so like I said, discussing the declarations page, coverage C covers your personal property. All right, so that's your stuff, okay? It doesn't cover your auto, all right? That's covered by your auto insurance. But it covers all of your personal property. So your books, your suits, your pots and pans, your dishes, your furniture, things like that, okay? So that is what coverage C is going to cover. So what's an example? Again, if you have, let's say that neighborhood kid is playing with firecrackers, a firecracker shoots off into your window, lands into your living room, burns up the carpet, burns up the couch. Okay, well, you're going to make a claim under coverage C, all right? Now, that could be a third-party claim too, but let's not get ahead of ourselves. At a minimum, you're going to make a claim under coverage C because your personal property was damaged. Okay, so what do I need to know about it? Well, again, common area of first-party and third-party disputes. I just kind of gave you an example of what could potentially be a third-party dispute. So you need to be aware of that. For the same reason, if you're dealing with A, you're dealing with B, chances are if the structure and any unattached structures were damaged, that the personal property in the dwelling and unattached structure were damaged as well. Right? That's common sense. So you're usually going to have A, B, and C together in that regard. Now, I want to be clear here because coverage C is not as simple as it appears to be. In fact, it's a fairly complicated area because you're dealing with the issue of depreciation. All right, so I want to talk about this for a minute. So here's an example. It's somewhat a ludicrous example, but I think it'll make sense. So let's say you have a $10,000 couch, leather couch you imported from Italy. All right, just a nice couch. All right, so you've had it for 10 years. All right, you've taken care of it, but you've had it for 10 years. Fire comes down, that fire from the hills again, burns up your property, burns up the dwelling, burns up the couch. All right, so you're making a claim under A, you're making a claim under C. The adjuster comes in and says, okay, well, I see you have this nice couch. And you tell them, oh, yeah, it's, top of the line, right? I got it in Italy, it was imported, real Italian leather, the works, yada, 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 pay $10,000. You're going to say, oh, well, that's nice. Well, how long have you had it for? And you're going to say, 10 years. And he's going to say, okay, 60% depreciation. All right, here's a check for $4,000, right? And you're going to be saying, what just happened here, right? So you need to get a grip on depreciation. And there's something that I want to point out. Now, what insurance companies and adjusters do is usually this. They go in and they'll say, okay, you're making a claim for all this personal property. How old is that personal property? Right? You got that suit. How long ago did you get that suit? You got that couch. How long ago did you get that couch? You tell them, and then they're going to come in and reduce the value of the property based on depreciation. They're going to say normal wear and tear. Now, I get that, okay? And intuitively, that makes a lot of sense. But here's the problem. The problem is that's not the standard. The standard is what's the condition of the item, not what the age of the item is. Now, again, I understand what insurance companies are doing because 9 times out of 10, right, the condition of the item is directly related to the age of the item, right? So, because think about it, it's your normal wear and tear, right? So as time goes on, you're going to use this personal property more and more, and so things are going to be, there's going to be some level of deterioration. Well, that makes sense, right? And maybe that makes sense in the example of the $10,000 couch. But that rule doesn't always make sense. So take this example. Let's say that when you're in Italy and you're busy, buying up these ridiculously priced couches, you said, look, I see this fantastic tuxedo at Milan, $6,500. You buy it, okay? Now, you go home, you put it in your closet, you put it in the tuxedo bag. You have it for 10 years, all right? Now, you only wear it to black tie events, right? And so you have the black tie events every 2 years, right? So you go to the black tie events, you don't spill any wine or whatever on it, right? You go home, you take it off, put it back in its package. You do that 5 times in a period of 10 years. Never even dry clean the thing, no stains, right? So, raging fire comes down, burns up the property, burns up the Italian couch, burns up your Italian tuxedo. The adjuster comes in and he says, okay, well, tell me about what you had in your closet. And you say, well, I had this nice $6,500 tuxedo from Milan. And they're going to say, well, how long did you had it for? You're going to say 10 years. And he's going to say, boom, I'm taking 60% off depreciation. And you're going to say, no way, right? Why? Because you're going to say, look, that thing is basically brand new. I took such good care of that tuxedo, right? You have to pay attention to the condition of the item, not the age of the item. Now, again, I bring this up because, again, a lot of times insurance companies are right by taking that depreciation, but I just want everyone to understand that depreciation needs to be based on the condition, not the age of the item, all right? Now, here's something to keep in mind with depreciation, and this is the last thing I really want to say about coverage C. Now, coverage C is an endorsement I recommend you get, and we'll get to endorsements in a minute, but basically I would recommend you get an endorsement, which is what's called replacement cost coverage, not actual cost coverage. So what that means is this. Let's say you have complete loss under coverage C. At $30,000, where the insurance company is going to come in and say, okay, well, you got $30,000 of, that's what's going to cost to replace some of the property you have. But if you have this replacement cost coverage, you're going to step in and say, okay, well, I want the money it takes to replace my items, right? Not the actual cost, because actual cost means depreciation, right? So the adjuster, again, can come in and say $6,000 off, 60% off, right? And you're going to be stuck there and saying, oh my gosh, right? But if you get this replacement cost endorsement applicable to coverage A, you push back and say, no, it's going to cost me $12,000 to replace that $10,000 couch, right? It's going to cost me $8,000 to replace that $6,500 tuxedo. So that's something you want to keep in mind. And frankly, look, these are ridiculous examples. I don't have a $6,500 tuxedo. I don't have a $10,000 couch. But I want to bring this to your attention because it's important to understand depreciation and the ways to avoid it. Because when you're dealing with a loss, and I speak from experience and working with clients, you don't want to have these nasty surprises, right? And you think you'll be entitled to something, but you're not because you didn't read or you didn't understand the contract. All right? So let's wrap this up with coverage D. Like I said in the beginning, it's a mouthful. So coverage D, ALE, additional living expenses, loss of use. So what does that mean? Okay, well what that means is additional living expenses. So let's break this down. Additional means it's an increase, right? It's not your mortgage. It's not your rent, right? But let's say that there was, again, fire comes down from the hills, burns up your property. Your property is going to take, 3 to 6 months to be restored. So where are you living at that time? You can't live at your home, right? Well, chances are you're renting a hotel. So that is an additional expense, right? Because you're paying for your mortgage, right? That's not going to be comped under ALE, but the monies you're paying toward the hotel is arguably going to be comped under coverage D. They are additional. They are in addition to what you're already paying. Secondly, they're living expenses, right? So living expenses is going to be shelter. Like we said, the example of the hotel, it's going to be food, right? It's not going to be, your new tuxedo, your new Italian couch, right? You're not going to get that. It has to be a living expenses. Now, sometimes you could get mileage for gas, right? Because let's say the hotel is 40 miles further away from your work, and so now you have a longer commute, you have parking tolls, et cetera, et cetera. Well, you can make an argument that that's recoverable under D. But basically, it's additional, so an increase of the living expenses. And frankly, this isn't a common area of first or third party disputes. It can be, right? And I will give you 2 examples when we get to disputes in a minute, because I think they're important examples of ALE, but basically it's not really common. So let me wrap up the coverage piece talking about peril. So what's a peril? Okay, a peril is a cause of loss, right? It's basically some type of natural occurrence that happens to the property, lightning, fire, wind, right, flood, okay, that's going to affect the property. That's a peril. So what you need to be aware of what's a covered peril. So when you look at these policies, there are really kind of 2 types here. There's what's called an all peril policy and a named peril policy. So let's break these down. Well, an all peril policy is actually a misnomer because it doesn't cover all perils, okay? What an all peril policy covers are all perils but the perils that are specifically excluded under exclusions, all right? And we'll get to exclusions in a minute, but that's really important to keep in mind because a lot of people get confused, right? Because they're going to say, oh, well, all peril, that's going to cover all perils. It's not, all right? The other one is going to be a named peril, and it's almost like the opposite of an all peril policy. A named peril is only going to cover the perils that are named in the policy. And frankly, that's the more common one is going to be an all peril policy. Sometimes you'll come across a named peril. If you have a named peril policy, what you need to do, even before there's a loss, is go to the go to the exclusions and say, okay, what's a named peril, right? Because that is the only types of perils that are going to afford you coverage under the policy. So you better know what they are. Flip side, dealing with all perils, you better know what the exclusions are and hope that you don't have one of those occurrences that are excluded under the policy, because if you do, there's no coverage. All right. So that's really it with the insurance agreement, coverages and perils. So then let's switch gears and talk real briefly about exclusion. So what is an exclusion? Well, I'll touch on that briefly. An exclusion is a peril that's not covered under the policy, right? So if there's no coverage for that peril, there's no coverage. That's the end of the story. Now, something to keep in mind here, and this is important. So what are some of the common perils? Well, what are the common excluded perils under the policy? So you're dealing with the H003 policy. Usually what you're going to have, the big three are going to be flood, earthquake, and war. So let me talk a little bit about each. Now, I want to talk a minute about flood because this is important, okay? Now, I've seen this from experience, personally, professionally. What happens, you have an all-peril policy, Most people, sophisticated or unsophisticated, lawyers or not, are going to think all peril, is going to cover all perils. So if the home is flooded, it's going to cover flood. That's not the case, right? And I've done my best to try to educate the public on that. It's simply not going to be covered. If you want flood insurance, you have to purchase it through the federal government. Basically, it has to be backed by FEMA. Now, sometimes FEMA will issue these policies through like Farmers or Allstate or something like that, so you can buy the policies from them. But you have to understand, it's a separate policy, right? It'll never, ever, ever be included under your homeowner's policy. It's a standard black letter exclusion, okay? So if you want flood coverage, you have to go out and buy a flood policy, all right? So that's really important to keep in mind. Now, secondly, earthquake. Okay, so California, that's a big deal, right? And frankly, that's on my to-do list to go shop around for earthquake insurance for our own home, because I know it's not covered under a homeowner's policy, right? That's another very common exclusion under the policy. Now, I don't think you have to go buy a separate policy. I think a lot of times you can buy a rider, which we'll get to in a minute. A rider is also known as an endorsement, which will afford you coverage for an earthquake under a policy, but very standard, it's excluded, there's not going to be any coverage, okay? So, lastly, war. All right, so, look, we live in a place, thankfully, we don't have to worry about war and things like that, but you never know, all right? So let's say some civil war breaks out, okay? If that happens and there's damage to your home, well, guess what? Not only do you have to worry about the war going on, but there's no coverage, okay? Now, frankly, you're probably never going to see that, thankfully, but just remember that these are very standard exclusions, flood, earthquake, and war, that are simply not going to be covered. All right. Now, few more pieces of information to keep in mind when you're dealing with exclusions. One is that the insurance company bears the burden of proving that an exclusion applies, right? And so that's important. So, because I've seen a lot of times insurance companies will come in and say, oh, well, this is a covered peril. And we'll talk about this more when we get to disputes in a minute. But this is a covered peril, and, therefore there's not any coverage. Well, you push back a little bit. You got to do a little bit better than that, right? They have the affirmative burden to show, right? And you'll see this play out when we talk about Hurricane Katrina in a minute. They have the affirmative burden to show that a covered peril, or that a peril was one that was excluded under the policy, right? So you really have to keep that. You have to keep that in mind, because that could be a do or die moment in litigation. Secondly, there's a lot of misinformation about exclusions for the reason I just talked about. You hear words like all perils, and there'll be coverage for water damage, but that doesn't include flood, and so it's really important for yourself and for your clients, if you're into this type of work, to understand what is included and what is excluded under a policy, right? Now, this brings us right into our next kind of topic, which is going to be endorsements. So like I said, you may be able to get coverage like earthquake coverage through an endorsement of the policy. So what's an endorsement? So an endorsement is also known as a rider, okay? So what that means, it's a part of the policy which modifies the rest of the policy, right? A lot of times you should see them listed on the declarations page. Now, they're not going to be spelled out what they mean, right? But you should see, the named insured, insured location, coverage limits, policy number, and then the the endorsement should be listed, right? So once you get past the declarations page, you get past the definitions, you get past the insuring agreement, you should get to the endorsements, right? And they'll say, one of one, one of three, right? And so you can leaf through those things, and you have to pay attention to them, right? Because they're important. So what are some examples? So we spoke briefly about one, and there's two I haven't mentioned. It all falls under C, so let's talk about that. So again, coverage C, personal property, art and jewelry they're going to be excluded. Okay, now it has nothing to do with perils. It's just about the type of personal property, right? So even if your house burns down and fires a covered peril, and it burns up all your nice jewelry and your art from Beijing, well, it's not going to be covered, okay? Because if you look at the policy, under exclusions, it should say under personal property, we're not covering art, we're not covering jewelry, right? That's why if you ever go buy, a jewelry, I know I had this when I bought my wife the engagement ring, you'll get, some offer to get jewelry insurance, right? So what you can do is get a rider or an endorsement that provides for jewelry or provides for art. All right, so that may be something you want to consider. You may not, but again, just understand that look at the policy, but your policy should not cover art, should not cover jewelry. So if you do want to cover it, you may want to consider getting a rider that would include coverage for art and coverage for jewelry. Now, the one that we talked about, okay, this was under the replacement cost value under the personal property, right? So again, the standard being if there's damage to the personal property, it's going to be actual cash value, ACV, but if you got the endorsement, you get replacement cost value, all right? So what that means is you can sidestep the issue of depreciation, right? So think about that ridiculous example with the tux and the couch. So that's something to consider too. I would, take a look at that. Couple of points about the endorsements. One is that endorsements can provide coverage when there was none. So look at the example we just spoke about, right? Art, jewelry. Normally that's not going to be covered under the policy, but if you buy this rider, all of a sudden, boom, you step in, you have coverage for those types of personal property, all right? Other thing to keep in mind is that riders' endorsements can expand the scope of coverage. Example, you take the replacement cost value, right? So what that means is now you don't have to deduct for depreciation, right? And so the scope of the coverage is arguably expanded in that instance. Now, also keep in mind that endorsements can be major, they could be minor. So, a minor one arguably is going to be, okay, your jewelry and your art, all right? That's not a break it or make it or break it analysis, all right? Major one could be an endorsement that changes the named insured or the insured, right? And I've seen that. So this is where you really have to pay attention. So let's take this back to the beginning. Your analysis begins on the declarations page, which is who is a named insured. Then you go on to the definitions to see if the insured includes, in addition to the named insured, someone else. But don't stop there. Then you have to look at the endorsements to see if there is an endorsement that changes the definition of insured or named insured, right? So that's the whole point of me coming at this and deconstructing it and taking it piece by piece by piece, because you have to focus on this policy and a piecemeal approach, and then you have to put it all together and understand it holistically, right? Last thing I want to mention about endorsements is that the endorsement controls over the insuring agreement, all right? And so that's going to make sense if you think about it. I mean, contract law, black letter contract law, the specific trumps the general, right? So if you have an endorsement comes in and it's going to change the terms of the insuring agreement, well, that endorsement controls, all right? Nothing else. So that's really it as far as a policy goes. So we went over the declarations page, we went over the definitions, we went over the coverages, which are found in the insuring agreement. We also discussed perils. We then went on to discuss exclusions and endorsements. So now we're going to kind of tie this all together and wrap it up with disputes. All right, so I want to talk about first-party disputes, and I want to talk about third-party disputes. Okay, so let's talk about first-party disputes. So what is that? What am I talking about here? Okay, well, it's a contract dispute, Okay? It's a dispute between the insured and the insurance company. And remember that a policy of insurance is, at its essence, a contract, right? And so if there's any dispute between the insured and the insurer, it's a contractual dispute. So that's a first party dispute. So I want to give you two examples. So one is going to be under coverage A, and then one is going to be under coverage D, which I told you I'd bring up. So let me talk about A for a minute. This is important. So the scope, there are really two disputes that can come up under coverage A specifically in a first party. It could be the scope of the damage and the coverage. Scope of the damage is going to be easy, right? Let's just say that wind tears off the roof of your home and you have $50,000 coverage limits. Insurance company sends their adjuster out there. The adjuster says, okay, it's going to cost, $10,000 to replace the roof. All right. Well, it's not a coverage limit issue. Okay, $10,000. But the insured goes out there, hires their own contractor. That contractor comes out and says, no way, $25,000. All right? So what do you do there? It's not a policy limits issue. You have the insurance company saying that the scope, right, is $10,000. Your guy is saying it's $25,000, right? So what do you do? So that's a typical one. That one's, fairly easy to resolve. Here's a more difficult one. Here's a more interesting one. So this is coverage dispute. Really what this means, this gets back to, so I want you to understand what is excluded under the policy. All right. This is what we saw in Katrina all of the time. So like I said, once I cut my teeth as a young lawyer doing these types of claims, as did almost every other lawyer in New Orleans at the time, right? So what you had was enormous loss all throughout the greater New Orleans area and the Mississippi Gulf Coast, okay? So a lot of times what you would have is, let's take a home that was missing a roof, right? So the insured would come in and say, okay, well, the wind took off my roof, which was covered, right? But wind-driven rain, right, then came in and soaked the interior of my home. It soaked the walls, ran down the walls, went into the carpet, went underneath the foundation, damaged all the personal property, my tuxedo, my couch. All of that stuff was wind-driven rain. That's covered under the policy, all right? Insurance company would come in and say, no way. That's not what happened. Okay, we'll buy that the wind ripped your roof off. Okay, whatever. We won't buy that it was wind-driven rain. Instead, it was flood water that came in, right? Insurance company will come in and say, you got to pay attention to what happened here. The levees broke, okay? And when the levees broke, the water rushed in, and it was flood water. It was external water coming into your property. That's what damaged your sofa. That's what damaged your tuxedo. That's what damaged the walls. Everything else not covered. Okay? So what do you do in an instance like that? Well, as us attorneys know, one side gets an expert, the other side gets the expert, and the experts duke it out, right? So you're going to say, okay, what was the cause of loss, right? And this scenario got played out so many times. So many times. It was, but it was the same dispute. It was wind-driven rain or flood, right? And we all knew flood wasn't covered under the policy, right? For all these people. I want to speak about this real briefly. So, a lot of times people are going to say, well, why don't you get flood insurance? Why don't you have flood insurance? Well, for one thing, it's not affordable for a lot of people. So we have to keep that in mind, right? Now, New Orleans, I want to bring this up. I don't know if everyone has been there. If you have, check it out. Great city. But New Orleans itself is a fishbowl. Okay, you have the Lake Pontchartrain on one side, and you have the Mississippi River on one side, and then you have a bowl underneath the sea level is New Orleans, city proper, right? So when the levees broke and all this flooding came in, the whole city was inundated. I mean, it was a mess, right? And a lot of people, rightly or wrongly, just did not have flood insurance. And so you just get into a crazy litigious situation with something like that. And I mean, this went on for years. But okay, enough of that. So let's talk real briefly about coverage D. Now, this is something I had come across. So Client had a condo in an HOA. Apparently, sewage pipe burst, and fecal water flooded his condo, brand new condo. Okay, very nasty situation. So he made a claim with his insurance company. He got monies under A, he got monies under C, he got a little bit of money under D, but he vacated the property. It would have taken some time for the property to be remediated because there were mold issues, there were sanitary issues, there were bacteria issues, so just kind of a nasty affair. He stayed the first month or so at a hotel. He incurred hotel costs. He turned it in to the insurance company. They paid it. All right. Now, at that point, he's a grown man, but he moved back in with his parents. Okay, while he was waiting, over 6 months or so for his condo to be repaired. So I was representing him, and after we had settled with the insurance company with A and C, we started to make some additional claims under D. Okay, and the insurance company's position was nothing has been incurred, okay? The client is staying at the homes of his parents, and so, there's no additional living expenses incurred. Problem solved. And, it's a good argument, okay? And look, I understand that, but we had to push back about it, right? One of the things was that, believe it or not, incurred was not defined in a policy. Right? And so what may seem unambiguous to one person may also seem ambiguous to another person, right? And also argue that, look, it's not right for the insurance company to catch a windfall. If my client did not have the good graces to stay with his parents, he could have stayed in a hotel for another 6 months and incurred these costs and let you foot the bill, you would have paid it, no problem, right? And their pushback was, look, it has to be incurred. And interestingly enough, when we kind of brief this issue back and forth, there's not a lot of case law on that. So that's, brings me back to what I said earlier, that it's not really a very litigated area. But, we wound up settling that thing and getting it done. But that's an example of a rare one. But that's an example of a first-party claim dealing with ALE. So that's really all I want to say about first parties. So let me kind of wrap this up real briefly with third. Before I do that, two things. One, first-party claim. You want to pay attention to the loss settlement provision in the policy. Okay, that is going to guide how claims are going to be settled and paid out. So if you're bringing a first-party claim, you better know that. Secondly, you better pay attention to the statute of limitations if you're dealing with a first-party claim. Now, most attorneys, I would think are going to say, okay, well, it's a contractual dispute. I get that. Statute of limitations on contracts are usually very liberal in most states, so they wouldn't be worried about it. But you have to look at the policy, because the policy should specify the time period in which to bring a claim against the insurance company. I've seen 1 year, 2 years, right? So you have to be aware of that. Once you have the claim, the client comes in, you start to investigate it. If you think this is a first-party claim, you better calendar at the very beginning what's the statute of limitations. Don't assume it's going to be the 4 years or whatever for a contractual dispute, because each policy that I've ever seen is going to have either a 1 or 2 year period in it. All right, so that's it for first party. Third party, what is it? Exactly what it sounds like. Okay, you're bringing a claim against a negligent third party. I mean, the first party sounds in contract. Third party sounds in tort. So usually, what I'm gonna plead is negligence, occasionally trespass, but it's going to be a claim you bring against a third party. It's just that a third party damaged your client's property, right? So that's really all that's going on. So I want to give you a couple of examples. I want to give you an example under A, C, and D real briefly. So A represented two homeowners whose homes were flooded. So to the east of their property, they had a construction company that was rezoning or redeveloping this neighborhood. And in the course of that work, they had erected this large holding pond for excess water and other type of kind of water that would just accumulate through the nature of the work. At the same time, we had historic rainfalls coming down in San Diego. And what happened was this. It wasn't so much that the holding pond burst like a bubble and you prick it. It was more like taking a full glass of water and holding it underneath a spigot that's turned on full blast, right? So the water just kept spilling out like this, and it started traveling westward to my client's property, completely devastating the property, okay? Of course, no flood insurance for these people. They had homeowners insurance, but flood wasn't covered, so what do you do there, right? So we developed a theory, liability, and brought suit against the construction company, right? Arguing for basically coverage A, actually everything else, real and personal property that were damaged as a result of the flood. So that's an example of, kind of coverage A third-party claim. Here's an example of a coverage C third-party claim. Life is stranger than fiction. Represented a family who had a very nice townhouse. Townhouse flooded. I think something went wrong with the pipes. The whole entire, this is before I got involved, the whole entire thing flooded. And so they made a claim with their insurance company. The insurance company paid out the policy limits, and then they started remedial work on the home. Now, either the clients or the insurance company had hired a contractor to perform remedial work during the restoration stage of the repairs. So what he apparently did was he was sweating some type of pipe with a blowtorch, and then a spark jumped out, went down the walls, burned down the property again. Okay, well, actually, completely damaged the property again. First water, then wire, then fire. So I got involved. The insurance company paid out, actually limits of all, A, B, C, and D. What happened was they reached the policy limits of coverage C, I think it were $30,000 or something, but that wasn't enough, right? And I think they even had replacement cost coverage, but they were still not made whole. There was an uncomp loss of, I forget the exact number. So in that instance, we just brought a claim against a contractor for the uncompensated personal property, right? Everything else was fine, but you still had the uncomped PP. So that was a claim we brought in that instance.
The second code is 362. The second code is 362.
Fourth and final example is going to be coverage D. So here's an example of a third-party coverage D. So I represented a woman who had a condo downtown San Diego, and apparently the upstairs neighbor was messing with the toilet plumbing or something, and the water came down and flooded my client's condo. So she made a claim with her insurance company, A, B, C, and D. They paid it all out. She had pretty high D limits. I think they were $30,000, but she got all that stuff out. So you fast forward 6 or 8 months later, she's still not in the home, right? She's used up all the ALE, so now she's incurring these additional living expenses. She had a lease with someone, and she was paying them, I don't know how much it was, a month or whatever, but we took the lease, and we took copies of the checks, and we turned that into the third party's insurance company and said, look, we want you to pay for this, right? And so we were able to get that claim resolved and get her compensated for that. And I bring that up because it's interesting for two reasons. One is that it wasn't a contractual claim, right? Again, remember, this sounded in tort. We weren't saying, hey, you're the first party insurance company, you owe us. We were saying, no, this is as a result of your negligence. And so how we kind of argue that is to say, look, a negligent party is responsible for all damages that result from his or her negligent acts. And so that's what we argue. This was a result of your negligent act, this ongoing uncompensated incurring of ALE. So we were able to get that done. Second reason why it's important is because we really had no problem getting that claim resolved because we had proof of something being incurred, right? We had a lease, we had copies of checks. Now you compare that to the other example I gave in coverage D, first party, where there was arguably no evidence of expenses being incurred. So real quickly, to wrap it up, there's a couple of things I want you to know when we're dealing with third-party claims. One is subrogation, okay? So that's an insurance company's subrogation rights, reimbursement rights. So if you're dealing with a first-party claim, the insurance company paid out their limits, well, at some point they're going to seek to be reimbursed for those, for the monies that they paid out, right? That's a reimbursement rights. Okay, that's fine, all right? But here's the problem. Let's say you had neighbor's kid shoots off a firework, lands over to your client's property, burns up their property, okay? It's a $100,000 loss. Coverage A limits were $200,000 loss. Coverage A limits were $100,000, okay? So now you have an uncomp $100,000 loss. The insurance company steps in, they paid your client the $100,000. Now there's an uncomped $100,000 loss because of the issue of underinsurance. You make a claim with the neighbor's insurance company. They say, hey, no problem, but I only have $75,000 in liability coverage. So what do? Right? Because now your insurance company is going to turn around and say, subrogation rights, I want my 100. You're going to say, no, I have my 100. The third party is going to say, I have 75K. Well, in California, it's the only time I'm going to mention California law, we have something what's called the made whole rule, which basically says an insurance company cannot step ahead vis-a-vis subrogation rights and insured unless and until the insured is made whole. So my parting advice would be, if you handle these types of claims, when you're looking at first-party claims, remember contract law applies. When you're dealing with third-party claims, remember that tort law applies. Thank you and take care.